Good morning and welcome. This is a joint informational hearing. The hearing on the Assembly side is being done by the Assembly Rules Committee. On the Senate side, it is being done by the Senate Elections and Constitutional Amendments Committee. The purpose of today's hearing is to implement the terms of Senate Bill 1253, which was signed into law in 2014. That piece of legislation said the following: each House shall assign the initiative measure to its appropriate committees. The appropriate committee shall hold joint public hearings on the subject of the measure not later than 131 days before the date of the election at which the measure is to be voted upon. Today, this joint hearing is called for the purpose of receiving information as required by SB 1253 on the California Legislature Transparency Act, which is proposed for the November ballot. We will today receive a brief overview from the Legislative Analyst's Office. We will then allow the two initiative proponents, Sam Blakesley and Dr. Charles Munger, to present their measure to us. There will be an opportunity for member questions, and there will be an opportunity for public comment. No action will be taken at today's hearing. I would also remind members that currently in the state Senate, there are two measures, SCA 14 and AB 884, which present similar requirements as the initiative. But I want to admonish everyone that today we are not discussing SCA 14, and we are not discussing today AB 884. Those are currently, appropriately, in the Senate for discussion and possible vote. And particularly for my colleagues in the Assembly, should those either of those measures move forward, they would come out of the Senate and be considered at a future point in the Assembly. So today, the focus of this hearing is strictly on the terms and conditions and the language of the California Legislature Transparency Act. And we welcome this opportunity to allow the proponents to present to us what their intentions are under this proposed act. With that, I want to introduce the co-chair of this hearing, who is the chair of the Senate Elections and Constitutional Amendment Committee, Senator Ben Allen.
Well, thank you, Mr. Chair. As I should just want to add that last week we had a hearing on those two measures that were mentioned by Assemblymember Gordon, and while this is a hearing on the proposed initiative, those two measures are very much part of the context of this discussion, and there's a lot of negotiation. I understand it's currently underway with the authors, and so this is part of this broader discussion that's happening between the legislature and the authors to see if we can come to some sort of mutually agreeable solution. That being said, this is also an opportunity for us to kind of hear publicly the issues that are being raised by the initiative and flesh out some of the core concerns that the initiative authors have. And we'll see, if you look at the Heerwagen initiative, for example, that process has actually worked seemingly very well, where Mr. Heerwagen came to the legislature, brought up a series of concerns that he had that were the impetus behind his measure, and then ultimately the legislature's moving on the core issues that he was bringing forward. So, thus avoiding a costly referendum battle between all sides. So let's see if we can get that here. And I'm looking forward to a good discussion. We had a good discussion last week, and this is all part of this broader, fascinating negotiation that we're engaging in right now. So I appreciate the chair's leadership on this, and I look forward to a discussion.
Great. Thank you. We'll begin then with an overview and fiscal evaluation from the Legislative Analyst's Office. And let me invite Ann Hollingshead, who is a fiscal and policy analyst with the LAO, forward for a presentation. Welcome.
Thank you, chairs and members of the committee. Ann Hollingshead, Legislative Analyst's Office. As the co-chair noted, we are going to provide some brief contextual remarks, just outlining an overview of what's included in the ballot measure today. But before I do so, I just wanted to briefly discuss our role, our office's role in these initiative hearings, because it's somewhat different than our office's role in sort of traditional budget hearings. So I'm also going to speak from a handout that you should have in front of you, and I'll turn now to the first page. Our office completes two types of analyses for every measure that qualifies for the ballot. The first is a fiscal analysis, which we conduct prior to signature collection. This is required by state law, and we do it alongside the Department of Finance. A summary of this estimate is included in the petition that is circulated for signatures. The second kind of analysis that we conduct is after a measure receives sufficient signatures to qualify for the ballot. And for this analysis, we again conduct a nonpartisan, unbiased analysis required by state law, and it includes a fiscal analysis and a description of the measure. This is included in the statewide voter information guide that is distributed to voters in California. We are still in the process of preparing these materials, but we are able to offer comments and answer questions based on the analysis that we've conducted to date. And I would also note that we do understand that there are ongoing conversations related to SCA 14 and ABA 84, but we have not completed an analysis of either of these measures, and so it's unlikely that we would be able to answer questions related directly to those. I'm going to turn to the next page and outline the major provisions of the proposed initiative. The initiative amends the Constitution in two ways. The first is that the legislature would have to wait 72 hours after posting a bill, including any amendments to that bill, on the internet before it would be able to pass that bill. This would include some exemptions for emergencies such as natural disasters. The second major provision is that videos of all legislative public proceedings would be filmed and then placed on the internet within 24 hours of that meeting. These videos would have to be publicly accessible and downloadable for a minimum period of 20 years following the meeting. There are a few other provisions associated with the initiative. First, members of the public would be able to film and broadcast any portion of any public legislative meeting. Second, it would amend state statute to provide that the members of the public would be able to use videos of any public proceeding for any purpose and without paying a fee to the state. And finally, any legislative costs associated with this measure would come out of the legislature's annual spending limit. I'll just conclude with our fiscal effects analysis of the proposed initiative. We estimate that the quantifiable costs associated with the initiative are related to filming and storing videos of the public proceedings. This would include both one-time costs and ongoing costs. Our office has provided a range based on some assumptions about what is likely to happen, but these are not definitive and they would change depending on decisions made in the implementation of the measure. The one-time cost would be of about $1 to $2 million per year, and this would be to buy equipment such as cameras in order to film all of the meetings. And then the ongoing cost would be about $1 million per year, and this would be for staff and the archival storage needs for the videos. That's the end of my prepared remarks, and I would be happy to take any questions.
Are there any questions for the Legislative Analyst's Office? Ms. Waldron.
Just a quick question regarding the cost. If, currently a lot of stuff is done digitally. It's not like the old time with tapes and storage and things like that.
Sure.
We're talking about buying cameras and equipment for some of the rooms that don't have cameras. How many cameras are we exactly talking about for $1 to $2 million?
So it doesn't just include cameras. It also includes some capital improvement needs that would need to likely use to change some facets of the buildings. For example, the legislature would likely need an additional control bay to operate the cameras. Perhaps one of the building rooms would need to be remodeled in order to include that control bay. There would also need to be mobile systems for field hearings, so those costs include those things as well.
Is there any administrative or salary costs, because you might have to hire people in order to operate those? Or
Yes, so the ongoing costs do include salary costs for the individuals that would operate the cameras.
Okay, so
As well as
that's the other ongoing costs of $1 million, so that's different from the purchasing.
Correct.
Online storage for videos.
That's correct.
Okay, thank you.
Mr. Cooley.
Just in the course of doing your analysis of the fiscal effect, are you trying to think about the issue of the requirement for 20-year retention, availability, technology, even in the last 20 years has greatly changed? And so I wonder if there is a long tail liability, so to speak, that as technology changes, if technology changes, that there is a cost to be incurred out of our operating funds to go back 5, 10, 15 years and re-up old video to match changing technologies, because there is a requirement, it has to be accessible for 20 years. So we sort of have to keep whatever the cumulative store is aligned with what is the typical technology. And I'm sort of, I can see that as a public good, but I also see that as something that if it comes out of the legislature's operating funds, one of my concerns generally is I think that the voters of California in the Citizens Redistricting Commission, in the top two, in the 12-year extension, have actually done a series of changes in recent years that I think are going to inure to the public benefit. We have longer-term members, more middle-of-the-road members trying to work issues through, a more engaged legislative membership. I think the opportunity in front of California, which the voters have set up for us, is to strengthen the institution. The former speaker, the current speaker, Mr. Gordon, you yourself, instrumental in pushing oversight, which is the legislature exerting oversight to the executive branch. This requires the work of and the focus of our chairs, our vice chairs, our staff, focus on what is the executive branch doing so it's subject to accountability by this body. And I see that as an area where probably, when you look at what the voters have done in recent years, this is where we can be more influential on the well-being of the state, so that the executive branch is held accountable to its co-equal branch, the legislature. But our operating funds can only go so far. And so I'm just very interested, as you analyze this, to think about this storage, archival, retrieval for decades, and is there an expense that's associated with it? Because that can come at the cost of us trying to do more collaborative oversight in our standing committees, which is the leadership that our current speaker is very interested in. So that's more of a cost dimension. Can you speak to that a little bit?
Sure. So we did consider the archival cost for a long period of time. We did speak with the state archivist as well in considering these costs. And as you note, there would be some uncertainty of those costs going forward. The costs could go up. They could also go down over time. That is partly the reason that we provided a range or a rough estimate of the cost going forward, because there is a high degree of uncertainty. But we did base the archival costs that we have on what they would be today.
Right. Okay. And I do know that is sort of typical that you will provide a range. So I'll look forward to seeing that. So thank you for that.
Thank you. Any further questions? Mr. Anderson.
When you were considering the archiving costs, can you tell me the components that you looked at? Because I know that the the cost of megs has gone down considerably, whether on the web or off the web, and so I'd be interested in the analysis.
Sure. So according to Granicus, which is a firm that does some storage for Cal Channel that includes some videos of legislative hearings, 10 terabytes would cost about $29,000 per year. That would be sort of at the low end of the estimates that we've seen. There is an effort in Texas to do something similar, to archive a great deal of legislative hearings and other public proceeding videos. And they estimated that the first year's cost of 183 terabytes, which is, you can think of many, 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 many hours of videos. It's probably much more than we would incur over even a few years, is about $156,000 a year.
Were you thinking that? So what comes with that storage? Certainly there must be more than just storage. They must also give you the ability to retrieve it and other items, because when I look at the cost at going, mind you, this is pretty simplistic, but when I go to Costco and I look at what I can purchase there, these prices are just astronomical. So that what else comes with these prices? Because certainly the storage space is not this expensive.
This does just include storage space cost, but it's sort of an enormous amount of data is the way that I would think about it. It's much more than you could purchase at a normal convenience store for.
Okay, thank you.
All right, if there are no further questions, thank you very much. And let me invite to the witness table Senator Sam Blakesley and Dr. Charles Munger. Gentlemen, welcome. As the Senator knows, oftentimes members must leave for other hearings, which is what I'm about to do. It is no indication of my desire not to hear what you have to say. And I hope to be back shortly, but Senator Allen will take over while I go present some bills in committee.
Sadly, you will miss the moment when I was going to thank you for all your hard work.
Proceed.
Very good.
Thank you, Senator.
Thank you, Chair. Thank you, Chair. Appreciate the opportunity to be with you today, and I do sincerely mean that I appreciate all the hard work by Assemblymember Gordon, in particular, Senator Wolk, on this issue of transparency, and I will say their staff as well. Craig Reynolds and Alf Brandt have been very helpful in many of these conversations, and I think I want to start off as someone who's been in the building and understands what life feels like on that side of the microphone, that these are complex issues, and staff has a lot of things they can potentially work on, and the fact they have reached out is something I appreciate. Let me also say that by virtue of my being intimately involved with these issues, I feel a great deal of passion around them. Having served in the Assembly, served as Vice Chair of Rules, as Ms. Ling does today, Ling Chang does today, and having served as Minority Leader and served in the Senate, I developed a great passion for this body and this institution. And when I left it 4 years ago, I wanted very much to remain engaged and seek ways to improve this body so that it could be all that it potentially could be. And the issues we've been looking at to help this legislature move forward are captured in this measure. I'd like to briefly describe some of the challenges and problems that we want to address, and Dr. Munger will describe some of the solutions and the implementation of those policy solutions. So first of all, what I found was very troubling as a member was to be sitting on the floor and suddenly find, and this is the time of year when these things happen, when the budget's moving, when you suddenly find measures that are literally in front of you, you have no time to analyze it, you have no time to read it, you have no time to call your constituents, you have no time to make sure that you know what is in that bill before you have to cast that fateful vote. And oftentimes all you have to rely upon is the respective caucus's recommendation. Aye recommendation, no recommendation. And you go in to the floor, there may be 50, 60, 70 bills that could get worked in a single day. and you have no choice but to vote what's in front of you without the information necessary. That is the gut and amend process that we want to put an end to once and for all. This should never happen to any legislator. Sure, I'm talking about the injustice to the legislator, but let's be frank, this is an injustice to the public. This is the people's house. This is where the people elect you to represent them. And how can you possibly do that if you can't talk to them before you cast a fateful vote on redevelopment, a fateful vote on the reserves for a school board, a fateful vote on SB 202 that deals with a measure of whether or not initiatives will be heard in June or November. These are examples of initiatives, bills rather, that have gone forward that had huge moment and effect on this body that weren't allowed to receive the kind of feedback from constituents that were necessary. So first, the problem is we as legislators, if I can include myself in that expansive we, are not well served by the gut and amend process. The public is not well served. And I'll point out the press is not well served. Oftentimes, the press, in doing their due diligence, will chase a matter down. They'll pick up the phone. They'll put people on the record, and they will discover things that, frankly, you or I or an average constituent would have no chance of uncovering, except for the fact there was a journalist who was ready to go and make those phone calls because they had the bill in chief before them. So the first issue we're really wanting to put an end to is this gut and amend process. There are other states that have found ways to solve these problems, and Dr. Munger will speak to them. And we think it's achievable. This legislature has talked about it for years, and there are members who are engaged today who we know have supported the kind of solutions that we'll be presenting. The number two area or problem we seek to address is what happens in committee. First was what happens on the floor. Second, what happens in committee. For any of you who have served in local elected government, you're very familiar with the public access channel, just clicking away, following you. You know everything you do is on the record. You know everything is in the public eye. It's no surprise that the cameras are going to record for posterity what's happening. In this building, here we are, in many cases, hundreds of miles away from our own constituents. They can't walk down to see us the way they see the city council member. They don't bump into you in the grocery store and talk to you about a potential bill. You're hundreds and hundreds of miles away from your constituents. And what is their ability to engage you or even see what's going on in committee? Well, if they're wealthy enough, they can hire a lobbyist. But the last time I checked, we're not here to represent lobbyists. Potentially, they can get on a bus if they can get a break from their job and drive up I-5 and get to this building and sit out there and watch what's happening. Doesn't happen that frequently. So what's the only other fallback position? Well, fortunately, we do have some video recordation. We have the Cal channel. We have some ability for our constituents to see what happens in these committee meetings. That's the second problem we want to fix. I'll touch only briefly on this statement that, we have enough transparency and we record enough hearings. There are many, many hearings which are not heard. And some of those hearings that are not heard actually have great moment, even there may not be a vote cast. So, for example, on the Prop 30 election of some years ago, there was an informational hearing not unlike this. But when it came time to hear the arguments against Prop 30, whichever side you're on is immaterial for the point of this discussion, the cameras were not lit up. And even last week, you saw in the Sacramento Bee, there was another hearing just like this, where the camera started and the cameras went off. And there were three different chairs. The different chairs said they didn't know who turned off the cameras. Rules said they didn't know who turned off the cameras. Leadership said they didn't know who turned off the cameras. And the final conclusion was it was the Cal channel that turned off the cameras. The article in question speaks to the condom bill in particular. And it's a very interesting piece of writing because it really details that this is a problem that's happening today. And it's happening with very little justification. The third and last problem I wanted to identify is what happens to those records that are created by virtue of video recordation and they're put in the public domain. You may not be aware of this because you may not have encountered it, but did you know, in fact, it's a crime to use these videos, at least assembly videos, for certain purposes. So for certain First Amendment purposes, such as political speech or commercial use, it can be a crime, up to 6 months in prison and a $1,000 fine for daring to use this material that's in the public domain. Now, you would think, well, but no one's ever prosecuted anyone on that statute, so it's not really all that big a problem. Well, actually, it's in front of a federal court right now because this has had a chilling effect on people being willing or able to use these videos, and our own Attorney General is seeking to defend the statute that makes it a crime to use these videos. Fortunately, a federal judge has stated he's going to likely establish an injunction, and the argumentation is moving very rapidly to support the concept that this is a violation of the First Amendment. But this is another problem, the third problem I wanted to identify. So those are the problems we seek to identify. I'll now turn to Dr. Munger, who will describe the approach we've taken.